If you've been injured in an accident involving multiple responsible parties, you may be wondering who actually pays for your damages. In South Carolina, the answer depends on the legal rule known as joint and several liability, which determines how financial responsibility is shared among multiple at-fault parties. Understanding this rule is crucial, especially if you're dealing with a complex personal injury case where more than one person or entity contributed to your injuries. Hi, I'm Auger Auger with Auger Auger, a family-run law firm serving South Carolina for over 30 years. Today, I'm breaking down joint and several liability, how it works, how it affects your case, and why having an experienced attorney is essential when dealing with multiple at-fault parties. South Carolina follows a modified joint and several liability rule, which means that in certain cases, one defendant can be held responsible for paying the entire judgment, even if others also share fault. However, recent changes in South Carolina law has placed limits on when this applies. Under South Carolina Code 1538-15, a defendant can only be held jointly and severally liable if they are found to be at least 50% at fault for your injuries. If no single party meets that threshold, each defendant is only responsible for their percentage of fault. For example, let's say you're in a car accident caused by two negligent drivers. One driver is found to be 70% at fault, and the other is found to be 30% at fault. Because the first driver is more than 50% responsible, they can be required to pay the entire amount of your damages if the second driver cannot pay their fair share. However, if both drivers were found equally at fault at 50% each, they would each only be responsible for their own portion of the damages. This law matters because in many personal injury cases, not all defendants have the ability to pay. If one party is uninsured, doesn't have enough insurance, or lacks the assets to cover your damages, joint and several liability could ensure you still receive full compensation by allowing you to recover the full amount from a single defendant if they are at least 50% responsible. However, if no single party reaches the 50% threshold, you may only be able to recover partial compensation from each at-fault party. This is why having an attorney is so important in cases involving multiple responsible parties. Insurance companies and defense attorneys will often try to shift blame among multiple defendants to avoid reaching the 50% threshold for any one party, limiting their financial responsibility. At Auger Auger, we fight aggressively to prove liability and ensure you receive the compensation you deserve. We conduct thorough investigations, gather crucial evidence, and use expert testimony to establish fault. We also challenge any attempts by insurance companies to downplay the responsibility of a major at-fault party. If you've been injured in an accident involving multiple responsible parties, it is critical to act quickly. Seek medical attention immediately, document everything, and avoid making statements to the insurance companies that can be used to minimize your claim. Most importantly, contact an experienced South Carolina personal injury lawyer as soon as possible. At Auger Auger, we understand how joint and several liability laws work and how to maximize your recovery in cases where multiple parties share responsibility. With over 30 years of experience, we've helped countless injury victims successfully navigate complex legal cases, and we're ready to do the same for you. With our A&A Zero Fee Guarantee, you don't pay anything unless we win your case. If you've been injured or need legal advice, call us today or visit our website to schedule your free, no obligation consultation. Let us fight for the compensation you deserve.